Hi everybody, thank you for joining this webinar. This is the first public law webinar in the series that 42BR have done. You'll find the private law webinars on the website and also on the YouTube channel, so you can catch up on anything that you've missed. For this evening, we'll take this introduction fairly slowly to let other people start to join. But there will be a Q&A box at the bottom of the screen that you're able to put your questions in rather than the chat box. And what we'll do is when we get to the end of the session, then we'll be able to address any of those questions, or the questions can be followed up via email after this session. An email that is going to contain this recording and also the slides and a feedback form, along with the handout that will accompany this session. That will be circulated in due course, and the recording will also be available on the website and the YouTube channel. So if we get straight into this session will be looking at supervision orders. And that's particularly after the responses to the Public Law Working Group from April 2023. And one of the main issues, and this is a question that was asked within the working group report, is whether or not supervision orders are worth the paper they're printed on. And so the background to the Public Law Working Group information, the document was published initially on the 15th of June 2020, and it contained best practice guidance for the use of supervision orders along with special guardianship orders, and that followed on from the case of REPS. But what the final report for the Public Law Working Group provided for, and that was on the 1st of March 21, was focusing on the use of supervision orders as standalone orders to assist with the return of children to carers who were bringing up the children prior to care proceedings. And so the report itself at paragraph 213 looked at the hierarchy of placement options, particularly looking at the preserving of families and the promoting of family reunification wherever possible. And it reiterated that it should continue to be the first priority within proceedings. And so paragraph 215 of the report provided in March, it said that the supervision orders were seen as relatively feeble tool that needed to be made more robust and useful. And certainly I think for anybody that's in practice, you will be very familiar with arguments as to whether or not supervision order actually does anything more than a child in need plan would do for the children. So the working group was looking specifically about how those orders could be worked with now, and whether or not there was anything that could be done now that would ensure that that could be used more effectively. So when considering their report, they looked at informations of outcomes from supervision orders that have been in place. And one thing that you'll see as you go through the report is there is a very clear lack of data. There doesn't appear to be a lot of data available looking at the outcomes of supervision orders and how effective they are. But from the data that could be collected, what the Public Law Working Group found was that there was a 20% likelihood of the matter returning to court for further care proceedings within 5 years of the making of a supervision order. Younger children under 5 were more likely to see a return to care proceedings. 10% of the supervision orders risk return to care proceedings within 1 year, and 24% of children experienced neglect or abuse during the supervision order, and 24% of those most suffered neglect, and most frequently the ages between 1 and 4. So looking at the outcomes from the data that was available, it became quite clear that there was still concerns within those matters where supervision orders had been made. And you'll see that the 10% return of care proceedings in the 1 year is a particular concern. Again, looking at the data, there was a follow-up after 4 years for making the order, and 24% of the children had experienced a permanent placement move. So that is quite, again, a high percentage when the supervision orders were hoped to be the solution to the difficulties. You then find that 24% of the children had experienced a placement move at that time. 28% were subject to further care proceedings, and 56% had experienced parental housing and financial difficulties. So again, for those practicing in this area, you will be familiar with the return cases when supervision orders have been in place. Another interesting piece of information that the Public Law Working Group came up with was looking at the variation of the use of supervision orders around the circuit. And so this is for year 2016-2017. And Northwestern Circuit, only 9% of cases use the supervision orders. Midlands, the Northeast and the Southwest, 12 to 14%. London, 25%, and that includes the Southeast. And Wales had the lowest use. So certainly there wasn't consistency around the circuits in relation to the use of supervision orders. So when looking at supervision orders, what the Public Law Working Group did was come up with the recommendations to actually have the supervision orders used to the best effect with the structure that they have now. And so within the report itself, and when you get the handout, there is a link to the reports at the top of it, so you'll be able to find these paragraphs. But in short, we have recommendations that have been made. And the main recommendation at 40 was for an additional subgroup to be set up to examine the supervision orders. They recommended that that subgroup was set up to review and make proposals relating to the practice, statutory guidance and regulation. And that was to enhance the effectiveness of supervision orders. So really looking potentially at reviewing the provisions in the Children Act 1989. Another recommendation, 13, was to ensure that the government reviews the components of a supervision order with the recommendation that they revise and provide more robust and effective form of public law order. So certainly within the discussions of the people that gave information to the Public Law Working Group, certainly there was a concern that supervision orders were just simply ineffective and that things needed to be done to make it more robust, and that couldn't be done under the present system. So the reflection of that you'll see as we come on in a moment is for things to be looked at more closely. And as I say, for there to be a consideration as to whether or not the Children Act should be amended to ensure that it can be more effective. But what the recommendations do within this report is it's recommended that the local authorities follow best practice guidance, and we'll look at the elements of that shortly. There was a self-audit questionnaire for local authorities to attempt to identify the issues that certain local authorities had. And also there are examples of local authority thinking tools to go back to basics and look at where things are in relation to the thinking around supervision orders. And so one of the main outcomes from the report is that they identified 3 overarching principles that should be in place when considering supervision orders and the support to be placed underneath that. And it was clear from that the child's welfare is paramount. So again, coming from the Children Act, but also emphasising that point when looking at whether a supervision order is firstly to be made, and secondly, what support can be placed around the family under the supervision order. It's also one of the overarching principles that the children are best looked after within their families, and their parents playing a full part in their lives, unless compulsory intervention in family life is necessary. So again, looking at one of the basic principles that we look at within care proceedings. That's reiterated when looking specifically at supervision orders. And also that any intervention should be necessary and proportionate, and that means the actions taken should be no more than is needed to achieve the aim of keeping the child safe and well. So the best practice guidance that you find within the report, and again, you'll be able to access that through the link in the handout, sets out what it is that should be happening. And what it says is that the supervision order plan should reflect these 6 core principles, and we'll look at those in a moment. And I think certainly for anybody that practices in this area, you will know and be familiar now with the new set out, or the new template of the supervision order support plans. And that really goes through to reflect the core principles and also reflect the work that should be clear and the way forward. And so the court should alert all parties to the need to read and apply the principles thoroughly. So the court will have an eye on exactly what the plan is, the supervision plan, the analysis in relation to the application for the supervision order, to make sure that there is a clear consideration of the 6 core principles that we look at as we go through. So we will look in the slides under separate headings in relation to the core principles, but in effect, the principles are the partnership and co-production with children and families. So when it says co-production, what it means is that the supervision plan should be a plan that's not just written by the local authority, but is a plan that should be provided alongside the children and their families. So there should be discussion in relation to the support that's necessary and agreed to, and that should find its way into the support plan itself. The second core principle is multi-agency and multidisciplinary working. So again, with a view to feeding into ensuring that all of the areas are sorted out for the family themselves, and so that the assistance provided under the supervision order is one that is done via the multi-agency network and through the multidisciplinary professionals. The third principle is the clear and tailored plan, including addressing ongoing risks in line with the findings and conclusions of the court proceedings. So looking at where the analysis has been undertaken in relation to the need for a public law order and the recommendations for the public law orders, then must be a clear plan that addresses the risks and issues that have been identified, so that there can be clarity around the support offered. The fourth element is the resource clarity. So this is to ensure that there is clarity as to what services are going to be available, where they will come from, and how they will be funded. So that's something that needs to be clear in the plan, again, so that the court can track through and make sure the core principles have been considered carefully. The fifth is the formal and robust review. So we'll look later on when we do these core principles separately, looking at the process of review. There's not going to be a statutory timescale in relation to reviews, but there will be a clear review process where the family and the child, depending on their age, will be involved, and it should be clear how that will happen. And finally, the core principle of accountability is one that is clear to be, or needs to be clear, so that it can be a clear structure as to who is accountable if things aren't working, and where things can go if there are difficulties. So as I say, in terms of the slides, the court will want to be satisfied that the proposed plan has been co-produced, and looking at the co-production, the court will want to know exactly what it is the local authority says will happen. So there should be plans, for example, for an FGC, if there's going to be family group conference support that's going to be looked at, or anything similar. So that can be a family group meeting. so it doesn't have to be as formal as a family group conference. But when looking at the co-production of plans, there needs to be consideration as to a wider family network or friends support network that could potentially provide the support that's going to be necessary within the plan. The court will also look at family insights and the resources in any family plan that have shaped the supervision plan that's been presented to the court. So again, looking more widely, not just at the professional network so far as the supervision order plan is concerned, but looking at any informal support network that could provide that assistance. There'll need to be clarity in relation to the risks and needs referred to in the plan, as I've said, one of the core principles, and it must accurately reflect the findings made. So the court will want to ensure that when you're looking at the analysis in terms of the supervision order, that there is identity, that there's clear identified issues, and then the support put into place to address those issues. And so that will also include what needs to happen to address any risks, and also a plan that needs to be understood by the parents and others involved. So it's not just a plan that will be looking at the issues. There has to be clarity as to the fact that the parents understand the risks, they understand the plan, they understand the support. And so sufficient evidence will also need to be in there about the resourcing of each of the element, as I said, looking back at the resource core principle. And then there has to be a level of confidence that the plan can be put into action promptly. So it can't just be, well, it's hoped that there will be support. It has to be clear that it can be put in place, and it can be put in place promptly. The reviews, as I've said, they have to be robust and they have to be formal. So the reviews need to not only be in the plan, you'll see at the very top of the new plan structure, it will see when the first review is going to be in place, but they have to be formal reviews. And they are detailed in the report, and the parents, again, will have to be very clear as to what their roles are and how they can get involved. And the plan itself has to be in plain language and understood by everybody. So again, back to the co-production point, there would have to be clarity in relation to the plan. It should be in simple language so a parent can have the document in front of them and know exactly what needs to happen. One of the other things that comes out of the Public Law Working Group is the suggestion that there should be clear recitals to the supervision order. So there's a lot of debate at the moment in relation to the use of recitals and potential overuse of recitals. But one thing the working group felt was important was that the recitals were used in a constructive way so that the reasoning behind the making of the supervision order could be clear and the support could be clear. And so in the event the matter does return to court and there needs to be court oversight in relation to the plan itself, and whether or not the plan itself has been an issue, or the support offered under the plan itself has been an issue, there can be a clear roadmap in relation to why the court felt that the order should be made and what the plans were. So in terms of the recitals, what the working group in the best practice has set out is that it should address why the order has been made and why it's been made for a specific length. So there can be clarity if, for example, it's been made for 6 months, why 6 months? If a year, why it's felt that that length of time was needed. Secondly, the parents, that it should be recited that the parents agree to the supervision order support plan and the actions set out in it. So again, coming back to the co-production point, in relation to the support itself, there should be a recital to the order that says that the parents agree supervision plan. So when representing for parents, it's going to be essential to have gone through the plan with them so that it can be clear if they have any questions, but also if they actually agree the plan moving forward. It should also be recited that the local authority agrees to provide and coordinate the services in the support plan. So again, back to the multidisciplinary points, there should be clarity that any support that involves multidisciplinary support is something that has been agreed, and that needs to be recited in the order. And also the local authority will need to confirm that each part of the supervision order support plan is resourced and funded. So that can be difficult in terms of local authority resource panels. That will all need to be dealt with before the plan is in place or is drafted, so that there can be clarity when you get to the final hearing that the funding is in place and that there's not going to be any difficulties in relation to the funding of the support. One of the clear difficulties, and again, those practicing in this area will know that there can often be difficulties once supervision orders are made. And if matters return to court, it's very often argued that the support plan wasn't robust enough or didn't provide the support, or that the support under the plan simply wasn't good enough. So the working group in the best practice has set out considerations regarding what should happen after the supervision order is made. If there's going to be a change of social work team, which is quite likely, the local authority must continue to provide that support. So that's not just a change of team after the proceedings have concluded, but also looks at a change of team within the life of the supervision order to ensure that on handover, the support that's to be provided under the supervision plan continues to be provided moving forward. Any amendments of support should be subject of discussions with the parents and others. So that's any of the family members, for example, that are also included in the support to be provided under the supervision plan. And any amendments are going to have to be confirmed with the parents, and will usually be raised in the reviews, as we'll see in a moment, but also should be just matter of course discussed with them. And so really it should be a two-way street. There should be consideration as to whether the parents feel that the support is working or if there are any issues that need to be addressed. One of the recommendations, as you'll see, is that parents should have time to take advice on changes. Now, that's not going to be funded. So that's going to be one of the issues that needs to be considered quite carefully, because funding necessarily will be difficult when looking at parents taking advice on changes. So that needs to be considered carefully by the social work team. But there simply won't be the funding, I understand, for there to be legal advice taken by parents if there's to be a change of provision. If the plan is amended, there should be an amended support plan prepared with the reasons for the change, and also that needs to be confirmed in writing. So again, it is a good idea in terms of that provision, but is going to need some thought and will need to be built into the review process in terms of what the amendments are, the reasons for the amendments, and that writing be in plain language so that the parents can understand it without having to go and get legal advice. So the review process, as I say, there's no statutory framework in relation to the review process. And what Core Principle 5 says simply is that it should be a robust framework for the processing, or so the reviewing the process. So local authorities will have their own structures in relation to the review process and how that will be done. But it should be clear, as should the support that the parents will receive when looking at the reviews and looking at how that will move forward. Again, parents may want to have legal advice, and as far as I'm aware, that's not going to be funded. So the social work team will need to think carefully about how that will be arranged, so that parents aren't left being confused about the review process. The guidance that's being provided in relation to the review process looks at the key features, and what the guidance or how the guidance describes supervision order plans is that they are bespoke. So they should be for each family, as should the review process. So there should be assistance in terms of family participation, and that's parents and other significant adults, as I've said, and they should be invited to attend. The child should be invited, obviously depending on age and understanding. And if that is to happen, then there should be careful thought given to how that happens, bearing in mind the varying different difficulties within the process and how the child would understand. So again, it's going to be of assistance if the plan itself is in plain language. That should be something that the child can then engage with in terms of their participation in the review process. The review process should also involve the agencies and organisations. So that's, again, we're going back to how the plan should be set out with the confirmation of the agencies and organisations that would assist. They should also be involved and should attend the review process unless reports are provided. So in the same sort of way that you would have multi-agency reports for child protection conferences, for example, that's the sort of process that was envisaged. And the review meetings should be chaired by someone who is independent of the day-to-day handling and hasn't got the managerial oversight of the case, so that we can have clarity in relation to the chair being independent and being able to look at the plan itself, and the frequency of the review process. Again, that's not set out, but it should really be in line with ensuring that the plan continues to be effective and of use to everybody that is being assisted by it. The first review process, that should provide the early oversight. So as I say, at the beginning of the form, the new format form itself, there will be the date of the first review. It would be helpful if that could happen after the change of team, if there's going to be one, and it should provide the early oversight of the plan services, the support and the resources to ensure that any early difficulties that are coming to light can be dealt with swiftly. And as I say before, the documentation, there should be an accessible note of the meeting. It should be written up and shared. It should be in plain language, and any actions can then be carried out. So as we go through the supervision order guidance, you'll see in the handout I've set out in a bit more detail the various issues. But as we go through the process itself, what the Public Law Working Group also did was recommended that this guidance should also be given when a child returns home with no order. So there's no prescriptive form in relation to the local authority final evidence. So unlike the supervision order support plan, there isn't an equivalent form. But what the Public Law Working Group said, and coming back to the thoughts in relation to the importance of trying to keep children with families if at all possible, and looking at the support services that would be available if the children were to return home. The Public Law Working Group felt that if children were returning home under no order, then the court should be looking and would be greatly assisted by looking at similar information as they would have if there were to be the supervision order plan. So what you will start to see is more consideration given to, for example, multi-agency support in the same way as you would look for under the supervision order plan, to ensure that once the family move away from the court process and once the family start to look at ways forward, there is going to be greater clarity with no order as to what the process will be. So, for example, if you have a child that will remain a child in need for a period of time after the end of proceedings, but with no supervision order, there will be an expectation that there will be some kind of clarity in the final evidence as to the support, how that will be done. There won't necessarily be the review process, obviously, because there won't be that process in train unless there is a child in need plan. But there should be the equivalent pieces of information so that there can be clarity. So coming out of where we find ourselves after the best practice has been set out, as I say, one of the very clear recommendations of the working group is that there is a lot more information that's obtained from the data as to the success of supervision orders, how often the cases return back into proceedings, and what the difficulties are. And it's hoped that by that process and the subgroup that is being set up to look solely at supervision orders, there could be greater clarity as to whether or not the orders are something that can actually support families moving forward. And a lot of practitioners within the work that the Public Law Working Group did raised the concern of this really being a blunt instrument, that supervision orders are not orders that can be strong enough to provide the sort of support that the families will need moving forward. And what can be seen is that very frequently the schedules that can be attached to supervision orders in terms of work that needs to be done, and that's under Schedule 3, 3.2 of the Children Act 1989. They're rarely used because they're just simply not enforceable. And so what the Public Law Working Group is hoping that as they go through, they've made supervision orders more robust in terms of the plans and the clarity of the plans that need to be in place if the court were to make the orders. Going back to looking at the data, going back to the subgroup that will look at this itself, it can look at the unenforceability of the schedules of the Children Act. It can look at what the issues are around failed supervision orders, so that in the future there can be more consideration given within the Children Act or with an amendment to the Children Act to ensure that the orders themselves can become more effective. So in short, the Public Law Working Group felt that supervision orders were worth the paper that they were printed on, but there can be a lot more done and a lot more understood in relation to the use of those orders and hopefully things done to make them stronger and of more use to families. So that is the end of the presentation. I think I'll have a look at the Q&A box. I think we've got one question at the moment. The question was, after the public law proceedings end, there is no further legal aid funding for the parents. How is it proposed that the parents will get advice about changes to the supervision order plan? So it comes back to what I said. There are no provisions at the moment for that funding to be made available. That is something that the subgroup will be looking at and will consider whether or not that's something that can happen. If there is an existing relationship between the parent and their solicitor, which there usually is after proceedings, then I think parent solicitors can expect to receive phone calls to say, look, this is what's happening, can you help? But as I say, there's no formal provision at this time for funding, so that is one of the issues that there will be. So we don't have any other questions that I can see in the Q&A box. So what can happen is any other questions that come up that can be sent via email through to the email address events@42br.com or directly to me. And they can be answered as soon as possible. And as I say, you will get a recording of this session together with the handouts that hopefully will be of some assistance. The next webinar in the series will be on Thursday, the 23rd of May. That is the public law update that's given by Amanda Jepson and Carolina Bax. So that can be accessed. If you go onto our website, you'll be able to click the link and register for that. And so it just leaves for me to say thank you very much for joining this evening. And I hope that this has been of assistance. Thank you very much.